Hi, my name is Alexander Baker. I'm reaching out to songwriters and composers, especially if you are a member of ASCAP or BMI, but really anybody who's interested in performance royalties. I'd like to take about 15 minutes of your valuable time to try to persuade you that the deal that you signed with your PRO deprived you of your civil rights, and that this deprivation of your rights is the root cause of the present threat to performance royalties. And for this reason, we are exploring the possibility of pursuing a class action lawsuit on behalf of ASCAP and BMI writers, seeking a money judgment to be divided among class members, plus a declaratory judgment that, number one, your ability to collect performance royalties through your PRO is a statutory right and cannot be waived as a condition of your signing a deal with the PRO. Number two, that your ability to sue your PRO is your constitutional right, including your right to pursue a jury trial, and that those rights cannot be waived as a condition of signing with the PRO. Number three, that your PRO may not stop paying you royalties simply because you sued them. And most importantly of all, number four, that your PRO owes you a fiduciary duty, including your right to an audit, which duty cannot be waived as a condition of your signing with the PRO. Who am I? As I said, my name is Alexander Baker. I hold a Juris Doctorate, and I'm currently working as a paralegal on 2 civil rights cases in the office of a notable civil rights attorney. The purpose of this memo that I'm reading is to explore the possibility of pursuing class action litigation against ASCAP and BMI for systemic violations of their members' civil rights and for breaches of their fiduciary duties. In full disclosure, I have a stake in this, for I am also a BMI songwriter and composer. For over 20 years, I wrote and produced music for film and television. And ever since my involuntary retirement and blacklisting, I have continued to receive performance royalties, at least enough to survive, while I pursue other goals. However, as of October 2019, that changed. BMI has now stopped paying me entirely for no valid reason. I believe it is related to exactly the civil rights issues that I am raising here. Because of my background in both music and law, I feel that I'm well positioned to speak to this issue. As we explore the possible solutions to this vexing problem, I invite writers, publishers, attorneys, anyone interested in performance royalties to contact me, either publicly or confidentially. The war on performance royalties. Discovery Network recently announced that they now require their composers to give up their right to collect performance royalties. It is feared that other networks will follow suit. I believe that this current attack on your performance royalties is made possible in large part because of the fundamental unfairness built into your PRO deal, or what they call a PRO agreement. While the form that you sign in having ASCAP or BMI collect your royalties is called an agreement, you did not have a meaningful choice in the matter. The terms of your writer-member PRO deal are strictly take it or leave it. ASCAP and BMI are breaching their duty to you. ASCAP and BMI, and CSAC for that matter, ought to respond to this problem by swiftly informing the Discovery Network that abolishing performance royalties violates the terms of their license agreements. But does it really? I'm not privy to the license agreements that Discovery Network signs with ASCAP or BMI. I don't know whether or not those agreements allow Discovery Network to just abolish performance royalties as they've now done. Logically, however, it has to be either one or the other, and it's going to be a breach of fiduciary duty either way. To see why, let's examine both possibilities. First, let's assume that ASCAP and BMI have done the right thing and included in their license agreements with Discovery Network a requirement that they actually pay performance royalties. If there is such a requirement, then Discovery's abolition of performance royalties is in breach of contract with the PROs. If the PROs don't immediately sue Discovery for a breach of contract, then they're breaching their fiduciary duty to their writers. On the other hand, let us assume that ASCAP and BMI have not done the right thing. Let's say that their license agreements with Discovery Network have weasel words that actually allow the network to abolish performance royalties, as they have now done. If that's the case, then the license deals themselves violate the PRO's fiduciary duty to its writers. No fiduciary may enter a contract with a third party that destroys the very purpose for which their duty arises. Allowing a PRO to license music to a network without requiring them to pay performance royalties, it's like hiring a property manager to collect rent for the use of your property, but then allowing them to enter into a third-party contract that says that the people don't have to pay rent if they don't want to. It doesn't make sense. How have ASCAP and BMI avoided responsibility? How are they able to claim that they owe no fiduciary duty to the writer when they so obviously do? To answer, we must appreciate that the PROs are subject to what is called a consent decree. As such, ASCAP and BMI are, for all intents and purposes, a government agency. Collectively, they might as well be called the Department of Performance Royalties. That, plus some unconscionable terms in the standard writer deal, have placed the PROs unaccountable and above the law. I believe that only a civil rights challenge can repair this. What is a consent decree? More than 70 years ago, ASCAP and BMI were sued by the United States Justice Department under the Sherman Antitrust Act for being monopolies. The end result was that the PROs and the Justice Department agreed to a set of rules under which the PROs would be allowed to continue operating. That is the consent decree, and it is the law, every bit as much as the Copyright Act is the law. What does the consent decree require? There are a number of points in the consent decree, and you can read the entire text in the info section below. The most important points to consider are these. Repping you is mandatory. Under the consent decree, ASCAP and BMI must collect and pay your performance royalties so long as you have at least one song published. Unlike other private PROs, like, for example, CSAC, neither ASCAP nor BMI may deny you membership. They have to take you. Membership in ASCAP or BMI is a right under the law. If this class action goes forward, we will ensure that mandatory membership remains in full force. Arbitration is mandatory. Under the consent decree, ASCAP and BMI must require you to agree to arbitrate any disputes with the American Arbitration Association. This is unconstitutional. The forced arbitration clause violates your First Amendment right to petition and your Seventh Amendment right to a jury trial. If ASCAP and BMI made you sign a contract that disallowed you from writing a song lyric, let's say, criticizing the President of the United States, you would be outraged. I would, because that would violate your right to free speech, which is found in the First Amendment. Also in the First Amendment, however, is your right to petition. And that is your right to file a lawsuit. Your PRO made you give up that right as a condition of membership. You should be just as outraged. Your constitutional rights were taken away from you. If the class action goes forward, we will seek a declaratory judgment that the arbitration clause is unconstitutional and your right to sue your PRO in a jury trial is restored. What else is unfair about your PRO deal? No fiduciary duty. The present version of the standard writer deal states that the PRO does not owe a fiduciary duty to the writer. This contradicts the very definition of a fiduciary. What is a fiduciary duty? The definition of a fiduciary duty is a legal obligation of one party to act in the best interest of the other party. A classic example of a fiduciary relationship is that between a broker and a principal. This describes the PRO-writer relationship perfectly. ASCAP and BMI contract with all of the TV networks, accepting fees in exchange for granting licenses for the networks to use your music. You rely on ASCAP or BMI to accurately survey the performances and to fairly allocate the money among thousands of other writers. The PRO acts as a broker in the deal where the network licenses the use of the writer's music. Another classic example of a fiduciary relationship is that between a trustee and a beneficiary. This too applies to the PRO, which is a trustee, and the writers who are beneficiaries. The PRO is charged with the responsibility to distribute the money fairly among the writers and to not engage in self-dealing, just as would be the case with a trust. There is simply no question that a PRO owes a fiduciary duty to its writer members, and yet they claim that they do not. And by now, the reason for this should be clear. Acknowledging a fiduciary duty would allow writers to demand an accounting, for example, including an explanation of the PRO's supposed secret formula by which they divvy up the money. And, most importantly, a fiduciary can be sued for a breach of that duty. The no fiduciary duty clause is unconscionable. If this class action goes forward, we will seek a declaratory judgment that a PRO positively owes a fiduciary duty to the writer. If you try to sue us, we'll stop paying you. The standard writer PRO deal includes a clause that states that if you try to sue the PRO, they can immediately stop paying your royalties. That too is unconscionable. Think about it. The way your deal reads, they're supposed to pay you. But if they don't pay you, or they don't pay you the correct amount, and you file a lawsuit, all of a sudden, they aren't required to pay you at all. Really? On what planet is that fair? If this class action goes forward, we will seek a declaratory judgment voiding this sue us and we'll stop paying you business. Confidentiality. If this class action goes forward, it would be under the absolute assurance that the identities of the writer-member plaintiffs would be strictly confidential and under no circumstances revealed to the PRO or to the public. Conclusion. In closing, I hope that I've persuaded you that the war on performance royalties is traceable to the unconstitutional and unconscionable terms under which the PROs are presently operating. The deal you signed was no deal at all. You had no bargaining power. I don't like what Discovery Network has done any more than you do. I agree with others. Shame on them. But no amount of public shaming is likely to do much good. Public shaming works only if you can hit them where it hurts, at the bottom line. In the last decade, there have been numerous cases of racism and sexual harassment where public shaming worked. But in those cases, Paula Deen, to name one, it was advertisers who pulled out their support. I would love it if Discovery's advertisers pulled out, but frankly, I don't see that happening. Most people just aren't that concerned about the plight of songwriters. Most people don't even understand that writers exist, as they are focused on music artists and the actors who appear on screen. If there's going to be a boycott of Discovery Network or any other user of music who is abolishing performance royalties, then the PROs are the ones to do it. They could, and in my view, should refuse to contract with any music user unless they guarantee that they will report and pay performances. ASCAP and BMI, as far as I can tell, are not going to do that. And while you're pondering why not, ponder this. Why are ASCAP and BMI still tracking performances essentially the same way they did in the 1940s? For the last 20 years, it has been technologically possible to track every performance of every song on every network and every radio station on Earth. Don't tell me it isn't. Ask FedEx where your package is. They'll tell you. Technically, it's the same kind of chore. And we know that composer and publisher data can be embedded into an audio file. ASCAP and BMI should have long ago developed a tracking app and required all their licensees to use it. There is no reason that you shouldn't be able to track the performances of your music in real time on your smartphone. I personally have been saying this for over a decade, and yet it hasn't happened. Other than a purposeful lack of accountability, what is the explanation? Songwriters and composers stand at a crossroads. Our choice is to just or excuse me, one choice is to just give up the fight and allow them to abolish performance royalties altogether. Then the PROs could simply die. Or if performance royalties are going to continue to exist, collectively we must sue ASCAP and BMI, demand the restoration of our civil rights, the right to a fiduciary relationship, and the right to sue them if necessary. Nobody wants to sue. If you never see the inside of a courtroom, you are living a charmed life, and frankly, I envy you. More than I can say. But the threat of possible legal action is the only thing that keeps organizations honest. Allowing ASCAP and BMI complete immunity from responsibility is the source of the performance royalty problem that we now face. Taking them to court with a class action civil rights lawsuit is the only solution, in my view. Agree or disagree? I would very much like to hear from you. Thank you very much for your time.